Hello. This afternoon, we're going to talk about inheritance tax for expats in Spain. So, I have with me my friend Ignacio from the firm Pellicer Heredia up in Alicante. Hello, Ignacio. Hello.
Hello, Michael. Good afternoon.
Hello. We also will have in a few minutes, I hope, Pedro Heredia from another firm up in the Valencia region. He's from Heredia. I think he's finishing something at the moment, but he'll join us soon. Okay, we're going to talk about inheritance tax, which is actually my favorite subject. I know it's a bit sad to say that your favorite subject is inheritance tax, but I've been doing it for 25 years, and I do enjoy the challenge of dealing with inheritance tax. Okay, inheritance tax in Spain is complex to understand. The first thing we need to get our head around is that inheritance tax is different depending on where you are in Spain. To make things a bit worse, inheritance tax has actually, the inheritance tax rates have changed in Spain quite a few times in the last 10 years. In Andalucía, for example, the inheritance tax rates have changed 4 times, in Valencia 3 times, in Murcia 2 times, and therefore, for clients that are trying to sort of look on the internet and find out what the inheritance tax is, it can be quite confusing because in each region of Spain we have different levels of exemption. Then we have this issue of the fact that the inheritance tax rates have changed all these times through the last 10 years. So you may be looking at a website that may be updated, maybe not. And then also inheritance tax rates can be different depending on whether you're a resident, non-resident, resident of the EU, non-resident of the EU. There are a lot of variables. So the first thing to understand is that it's complex, and that when you're reading about this on the internet, it will become quite confusing, and you can get things very wrong. So with that, let me explain sort of how it works. In Spain, we have a general system for non-residents. Now, the general system for non-residents set by the Spanish National Tax Office establishes very low exemption rates, slightly higher for spouse and children, and higher rates as you get further away from the person that's deceased. In other words, what you pay in inheritance tax depends on your relationship with the deceased. The further away, the higher inheritance tax. Now, the thing is that the government establishes these general systems and very small exemptions, but then each region of Spain have been allowed to create extra exemptions. And in some regions of Spain, these exemptions are extremely generous. So applying the correct exemptions corresponding to your region is very, very important. The other thing to understand is that in Spain, inheritance tax is almost always paid by self-assessment. So if you get things wrong and you don't apply the correct exemptions, you could quite easily overpay, and it's doubtful that the taxman will bother to come after you to repay you what you paid extra, unless somebody puts in a claim. Okay, so with that in mind, let's talk about inheritance tax. I will talk about inheritance tax in Andalucía, which is where I do 90% of my work. But we do understand, control, and handle estates all over Spain, and we are completely familiar with all the exemptions in all the regions. We've got with us Ignacio and Pedro today. Well, at the moment Ignacio, later on Pedro, and they're from the Valencia region, so I'll let them explain what the exemption rates are up there. In Andalucía, up to a year or two ago, the system of exemptions was not very generous. In fact, in the old days, we would recommend as tax planning effort to have people buy themselves a flat up in the Valencia region and go on the padrón and things over there, because inheritance tax over there was more beneficial than Andalucía. Now it's completely the other way around. Andalucía now is a great place for inheritance. So not only is it the best region in Spain, as far as I'm concerned. Ignacio will probably say otherwise, but there you go. I reckon we've got a magnificent region. You've got a bit of everything. Marbella and its golf courses. You've got Seville and Cordoba with and Granada with their culture. We've got so many things going for us. And now we've also got a very generous exemption rates. In the old days, when people used to say that Andalucía was going to be the Florida of Europe, in the back of my mind, I always knew that it wasn't quite true, because one of the reasons Florida is such a popular place to retire to, apart from the sun and the beaches, is that they have very generous exemptions for inheritance tax. That is one of the main reasons. Now, we've got them here now in Andalucía as well, so we now really can become the Florida of Europe, but much better. Okay, now the deal in Andalucía at the moment is that if you're receiving an estate from your spouse or from your parent, each child is entitled to up to €1 million completely free of inheritance tax. So, for example, if you own a villa in Marbella that's worth €1.5 million between two spouses, and you leave half your villa to your spouse, for her it's going to be exempt, as long as her pre-existing wealth is also less than €1 million. So if she receives €750,000 and her pre-existing wealth is less than €1 million, it will be tax-free. Okay, so well, that's a great thing. And with the children, you had a villa, even if it was worth €4 million, you leave your villa to €3 million, you leave it to 4 children, it could be tax exempt as well, as long as their pre-existing wealth is not more than €1 million. This exemption that used to only apply to the residents, beneficiaries that were residents in Andalucía, thanks to a sentence by the European Court of Justice, is also now applicable to non-residents that are resident in an EU country, but are inheriting in Andalucía. This has concerned a lot of people because of Brexit coming up, but it looks like non-residents that are resident in non-EU countries are going to be covered as well. It's not as peaceful as with the residents of EU countries, which has been applied by law in Spain, but there are various sentences that say that this can be claimed also now by residents of third-party countries. More sentences we're hoping will be on their way, and then maybe they will actually turn this into law. So those are the basic exemptions in Andalucía. I'll pass you over to Ignacio. Ignacio, perhaps you could just go through the basic exemptions over there in the Valencia region. And while you're doing that, I'm going to plug my laptop in. It's just about to run out of battery. Okay?
Okay, can you hear me, Michael?
Yes, perfectly. Perfectly.
Okay, well, thank you for the invitation, Michael. Now, it is a very interesting topic about inheritance tax, and it's very important for people to start doing tax planning. As you said, in some places are beneficial in certain years, and suddenly they remove that exemption and it disappears. A clear case, it happened, that was in Comunidad Valenciana and Murcia, which we did have, Michael, 99% reduction. So pretty much like in Madrid, didn't pay any inheritance tax. Unfortunately, after the credit crunch, Michael, they did remove that allowances. And at the moment, I could tell you how it works. I remember in the old days saying it's more expensive to die in one place or the other, you know, and I'm sure you would agree, but it's never, we're never able to say that because, you know, the laws change often and it's a very, very hard.
Ignacio, you're saying that now because now we've got the good deal. In the old days, what clients are aware of sometimes, we would recommend our clients in Marbella who were trying to do estate planning, we'd have to recommend that they go and buy something up in the Valencia region and we'd pass them over to Ignacio, and that was very painful for us as a firm. But now it's going to have to be the other way around.
Goes the other way around.
Okay.
Now, unfortunately, now in the Valencia region, Michael, we've got only, well, as you said, because of the sentence for resident and non-residents, we use the same allowance. We've got on the main property 156,000 euros. Up to that money on the main property, habitual house, what your permanent house, you've got 95% of that tax reduced, okay? And then you have on top of that another allowance of 100,000 euros, right? From that, you've got a sliding scale, which is a state tax scale, right? And we will only be allowed to have a 50% discount or reduction on the final tax amount you will pay. As I said, in the old days, it was excellent 99, but now it's only 50. I wish they will remove it eventually, but we don't know, Michael. So that's exactly what is happening now, Michael, in Costa Blanca. I wouldn't be able to, that's always from husband to wife, wife to husband, and then to the children. If it goes to different relatives like sisters and brothers, they will not use the same allowance. It's important as well for them to be aware and reflect whether they're married or they're just living together, because there is no allowance at all like friends, you know, and there is a lot.
Absolutely, yes, that's very, very important. Sometimes the best estate planning, the best, most complex and best lawyer in the world can't beat simply getting married as far as handling the estate. The difference is incredible, whether you're married or you're not married.
But Michael, I'm sure it'll be hard for us to say the best solution will be to get married, isn't it? Because
we've done it sometimes, and we've even had people get married in the hospital. So there you go. It does. Yeah, it's definitely yes. In Spain, speak to a lawyer about this. But the difference between being married and not being married for inheritance tax, you literally won't believe it. The difference is incredible. So that's a very important tip to get. That's
a good tip, Michael, to remind about living together. A lot of people say, "Oh, because in my home country is the same in different countries." You know, in Spain, if you're living together, you don't have any rights. Even if you have pareja de hecho, you wouldn't have. At least in Comunidad Valenciana, Michael, I don't know in Andalucía, you will not have these allowances.
Yeah, no, in Andalucía, there's before gay marriages became legal in Andalucía, it was quite easy to join the parejas de hecho registration system, and because they were trying to avoid the discrimination, they were quite flexible and they allowed this parejas de hecho thing. But since gay marriages have become completely legal in Spain, the tax office looks with absolute suspicion to anyone that all they've done is register in the parejas de hecho registration. Because they say, look, well, why don't you get married? And if you don't believe in the church, go and get married in the town hall. It's a contract. At the end of the day, that is really the only thing that will guarantee that we will allow you the exemptions. In other words, it's either you're married or you're not married. The parejas de hecho situation is not a guarantee. Do not go down that route, whatever people say. It causes lots of problems when you do the tax declarations.
A different topic, Michael, I don't know if you went through, is different allowance with different relatives. Is there different in Comunidad Valenciana? Is there different sliding an allowance for for sisters?
Yes. Well, I think obviously that's a long issue, and we'd have to go into it. But I mean, as you know, in group 3, the only allowance in Andalucía is €8,000. That's basically sisters, brothers, and cousins. And then you apply the sliding scale from 7 to 36%, and then a multiplier of 1.58 at the end. In other words, it's expensive. In other words, cousins are expensive, and to leave something to your neighbour is even more expensive. So basically,
just correct me if I'm wrong. In Andalucía, family is protected. Is that correct? It's group 1.
Yes, group 1 and group 2, spouse and descendants, even grandchildren. That's what they protect. Ignacio, I was going to say something else that we're coming across quite a lot now over here. And I've literally seen three cases in the last 2 months. It's becoming, I can see people need to be aware of this. People don't quite understand the trade-off between inheritance tax and capital gains tax. And this is a big, big issue, and we're seeing big, big mistakes. Now, what happens is a lot of people, and sometimes some solicitors as well, we're used to the old days, because in Andalucía, up to a couple of years ago, inheritance tax could be a big deal. You could pay a lot of inheritance tax, €200,000 on €1 million exemption, inheritance. So it was a big deal. Now we pay small amounts. So taking into account the first million is exempt, and after that you get a 99% exemption, the inheritance tax we pay is very, very small. I mean, we're talking about up to €1 million exempt, and even if you inherited €3 million in Andalucía, let's say your spouse leaves you a villa worth €3 million, you'd actually only end up paying 10 or 11,000 euro. So you don't want to save on inheritance tax. And what we're finding is that people sometimes are undervaluing on their inheritance deed. Okay, so for example, they're inheriting a villa worth 600,000 euro. And out of the old custom of trying to go as low as possible, because they're trying to avoid inheritance tax, they go and put 300,000 euro on the title deed. Then 3 months later, they sell the villa and they're selling it for 600, which is the real price. And they're receiving a bill for 24% of 300,000 euros. So they're suddenly paying a 60,000 euro tax bill, which could have been completely avoided by simply saying the true correct value on your inheritance deed. And under €1 million, it's exempt. So even if you're inheriting, say, a villa, if you're inheriting a villa worth €3 million, you roughly pay at the moment, as long as your pre-existing wealth was less than $1 million, in Andalucía you pay 10,000 euro. So you inherit the villa, €3 million. The next day you sell for €3 million, free of capital gains tax. But what we're seeing is people are inheriting for €3 million. They're saying that it was worth €1 million on their inheritance deed. The tax office doesn't really sort of look into it very much if they undervalue. They're looking at whether they overvalue, because inheritance tax office is one and the capital gains tax office is another. So they go ahead, put €1 million, then they sell it for 3 million, and guess what? The taxman sends them a bill, 24% of the 2 million. And we're seeing this, so 480,000 euro that is literally just being thrown into the rubbish. We've seen this. We've seen it 3 times in the last few months. It is unbelievable how much this is happening. The other day, I spoke to a lawyer about this to see, because his client was saying they wanted to sue the solicitor that handled inheritance for having undervalued the property, causing them an extra 60,000 euro in capital gains tax that was unnecessary. Well, guess what happened? I spoke to the lawyer, this is in Marbella, and he says, Michael, it wasn't me. The valuation was given to me by the clients. The clients, from what his side of the story was, that his clients had given him a lower value, because the clients in their own mind had been told, careful, don't give too much of it. The higher the value, the more taxes you're going to pay, the more fees you're going to pay. So they didn't say the truth to the lawyer. The lawyer accepted what they said was the value. He went ahead and valued, and then they got the 60,000 euro capital gains tax bill. So this is something that is, I think it's the biggest mistake that happens at the moment. And it's happening because we've only just recently changed from a system where inheritance tax was very, very high to a system where inheritance tax is extremely, extremely low. But capital gains tax is going to be calculated on the difference between what you sell the property for and what you declared you inherited for. So this is, I don't know if you're seeing this one, it won't be such a big problem up in the Valencia region because you've got inheritance tax to deal with. So if you lower the value on the inheritance deed, you're saving some inheritance tax. But here, they're saving almost nothing, and it's costing them a load of money on capital gains tax. So that's something that people need to be aware of.
Yeah, I think it's very important topic what you're talking about, and I think clients should be aware of these things, because we're talking about a lot of money throwing, as you said, into the bin. You know, and I've seen it in the past, Michael. As you know, Comunidad Valenciana is being going up and down from the inheritance tax, and I've seen all kind of stories. Unfortunately, I fully agree. Some people just trying to underdeclare or declare the minimum with no advice or probably not information. They did declare very little, and then the capital gain tax is big. Every time we deal with this in Comunidad Valenciana, Michael, in our office, we always do the tax planning ahead. So we try to minimize that, and I think that's a key, and everybody should do tax planning ahead, Michael.
Yeah, Ignacio, can you hear me?
Yes.
Okay. Yes, absolutely. I mean, the thing is at the moment is that basically in Andalucía, it's very easy nowadays to avoid inheritance tax because, as I say, you know, we've got this €1 million allowance, so it's close to nothing, and it's close to nothing. So there is no need to pay inheritance tax in most cases. So you just need to sort of look in it, spend 10 minutes with a lawyer, 20 minutes, go through it, and normally, you know, in normal circumstances, if you've got close family, you'll be able to leave things to them in Andalucía and pay no inheritance tax. What was I going to say? I got lost in thought. Then I was just
Michael, on the panel. I think we're receiving lots and lots of questions, aren't we?
Yes, I'll tell you what it is. Okay. Yeah. Okay. Yes. Let me see.
Right.
Okay. How long? Okay. Peter Pascoe is asking, how long do you have to pay? How long have you got off the debt to pay inheritance tax? And then, if I am late, what happens? How much are they going to fine me? Do you want to answer that, Ignacio? Or?
You go ahead first, Michael, and we can compare.
Well, at least here in Andalucía, the maximum timescale is 6 months to pay the inheritance tax. Or, even if there's no inheritance tax, within those 6 months, you've had to make a declaration declaring it on the self-assessment form, declaring that there is no inheritance tax within 6 months. If you feel that you won't be able to make it on time, during the first 5 months, your lawyer will be able to request an extension. In the case of expats, they automatically grant it and give you another 6 months. 6 months. So in total, you'd have 12 months to make the declaration. Regarding the penalties, for the time from the 6 months onwards, what they do is the first 3 months delay, they charge you 5%. Between the third and the sixth, 10%. Between the 6th and the 9th, they charge you 15%, and everything over a year is 15%, and everything over a year is 20%, and after that, 20% plus legal interest. This is on the tax that you should have paid. Now, people need to realize that this is if these penalties are the ones that they apply if there has been good faith. Now, for it to be good faith, it has to be you presenting the self-assessment late. If it's on the other way around, you don't make a declaration and the taxman writes to you saying, hey, your husband passed away 9 months ago and you've never made a declaration, what's happening? The fines can be much, much more because they can consider there's been bad faith. So if there's good faith, those are the penalties, and therefore it's not a big problem, but obviously it depends on the amount. If there was no tax due, and you're late on making the self-assessment saying that there was no tax due, normally from experience they send you a bill for €150 for late presentation of tax forms. It's per tax form, so there's 4 beneficiaries, 4 lots of €150. The best thing obviously is to do it all on time. I don't know about how long it normally takes up it there, Ignacio, but down here, if it's a probate with a will, to wind everything up should normally take 3 to 4 months, so there should be plenty of time. Is that roughly how long it takes up there?
That's right, Michael. It's exactly the same, Michael. Now, normally, I could tell you the time frame that we're dealing with. Normally, 6 months is more than reasonable, but there is another extension that allowed by the tax office. After the year, you'll have a surcharge, obviously, on the interest that you surcharge on the interest, and it is up to the time the taxman could go and review. We're talking about 4 years in Comunidad Valenciana. I think is similar in Andalucía, isn't it, Michael?
Yeah, absolutely. Yeah.
So that's basically it. That's basically in Comunidad Valenciana.
Excellent, perfect. Ignacio, you mentioned, I think, that you'd had some questions through on the email. Have you got those, or should we answer these ones that we've got through on the Zoom here?
Yeah, I've got there are some here on the Zoom, Michael. Shall we start with the Zoom?
Okay, let's see. My lawyer in the UK is saying that he needs proof of the valuation of the Spanish estate and taxes paid in Spain, etc. Have you ever been in the situation before when an English lawyer is asking for proof regarding Spanish estates? If so, what do we have to do. Okay, well, this is very straight. This is very simple. In the old days, when we quite often, if the client, apart from the assets in Spain, has assets over in the UK and he's doing probate in the UK, there comes a time when on the forms for the taxman in the UK, they have to declare if there are any assets abroad. Once they've ticked the box saying that there were assets abroad, it's normal for their lawyer to ask some questions about the assets abroad. Now, in the old days, and technically, the correct thing we always felt was one had to take the title deed of acceptance of inheritance and all the tax forms in Spain, have the Hays Apostle on them, send official translations, etc. We discovered 7 or 8 years ago, and since then we've done it every single time this way, that even though technically that's sort of how we do the international validations, what we always do now is we just prepare a letter on our letterhead where we always explain in English, we make it look very formal, saying that our client in Spain has accepted an estate total value of X amount, and that we personally have presented all the inheritance tax forms and that we've paid X amount of tax. We sign it, stamp it, and we send it off to the lawyer in the UK. And since we started doing it that way, we've never had a problem. So, so I don't know if you do it that way or not, Ignacio. But we were guilty also in the past, because I don't know, probably some people still do it this way. Of we tried to do it the official way, how it would work if it was coming from England to Spain. So we did the Hays Apostle, did the official translation, but a letterhead from the lawyer in Spain, written in English, is perfectly acceptable by the solicitors in the UK, because in turn it's acceptable by the tax office in the UK as well. So that's how we sort that one out. I don't know. How do you do it, Ignacio? Do you do it that way as well, or what? Yeah,
Michael, it's pretty much the same. I think. Did we answer the question about Plusvalia, Michael?
Okay. Yes. Apart from inheritance tax, when you receive an estate in Spain, and if there's real estate involved, apart from the main one, which is the inheritance tax, there's also a tax called Plusvalia tax to the town hall. Now, when we talk about Plusvalia tax, forget completely about all the issue of what you value the property at and all these things. It's irrelevant. Why? Because the Plusvalia tax is a local tax charged by the town hall on the difference in the catastral value, that's the rateable value from the moment it's purchased until the moment it's inherited. And it's not on the value of the complete property, it's only on the value of the land under the property. In other words, and the valuations have got nothing to do with the valuations you give to the inheritance. I know it sounds a bit crazy, but that's how it is. They completely work in parallel. And with the Plusvalia tax, up to 3 or 4 years, this was almost like an afterthought and a very small issue, because the Plusvalia taxes tended to be very small. This is no longer the case. Plusvalia tax can be quite substantial nowadays. We recently paid one down in Malaga, €21,000. It was a house with a lot of land, urban land, and they'd had it for 30 years. So it can be a substantial amount, unlike in the past. And what happens if I don't pay my taxes? Okay, well, if you owe taxes and do not pay them, you'll get into a lot of trouble in Spain, because they will throw a lot of surcharges at you. And if the inheritance tax office decides that there's bad faith in the non-presentation, in other words, not that you've just forgotten, but you're trying to avoid paying the inheritance tax by waiting for statute of limitation and things like that, they can really throw the book at you. And the end result of any debt with the Spanish administration is they eventually embargo your properties. So very dodgy. With the Plusvalia tax, it's the same thing. The way the Plusvalia tax works is that the moment you sign the acceptance of inheritance deed, the notary by law has to inform the local town hall. As if there are properties in the estate, it's the notary that has to inform the town hall that the transaction has taken place, telling them what is the catastral reference of the property and the date it's been inherited. And then it's the town hall that will calculate what the Plusvalia tax is and send out the bill. And if it's not paid, yes, they'll eventually embargo properties, bank accounts, and all these things. In other words, you cannot become a rebel and not pay. Also, with inheritance tax, they've got a very simple, straightforward way of controlling it, and that is that when you sign an acceptance of inheritance deed, until you can prove to the property register that you have tax clearance from the inheritance tax office, signed, sealed and blessed, they will not register the properties in your name. And with the bank accounts, it's the same. The banks will not place the accounts in your name, even if the deed of inheritance has been signed, until you prove to them that you've got full clearance from the inheritance tax office. So that's how they control it.
Michael, I'll just, going back to the valuation, I think is very important to have it always to cover your back, obviously. Even on the conveyancing side, when you're buying very cheap property as well, I don't know if it did happen to you in Andalucía, but for inheritance tax, especially now, I really think is the best way to protect yourself, because tax office is going after, as you know, sending a lot of nice letters to all of us and asking to give us an update on why did we value these or the other. So it's highly recommended, and I'm very fond of using surveyors every time we move forward, because that really is a great evidence in the future for you to support your allegation why you did declare that inheritance.
Yeah, no, absolutely. Whenever there's any doubt, evaluation is always a good idea, especially in the case of Andalucía, where what we're trying to do at the end, in most cases nowadays, contrary to what used to happen, is people try to place the value of their assets as high as possible because they know they're going to pay little or no inheritance tax, because it reduces the capital gains tax going forward. I mean, I say, as I said before, if you're inheriting a property of 500,000 and you put 100,000 euro on the title deed, right then it's cost you over 80,000 euro because the capital gains tax liability is there. While if you put the 500, you could sell it for free. Some people, even they inherit for 500 and they try and, they get a valuation, try and get it as high as possible so that it takes them to 550, and then they put that in the time. And then if they're trying to go as high as possible, what we see people do is they get the valuation so they can then put it into the title deed and then use that to defend the price if the capital gains tax people in the future think that you've overvalued. But here in Andalucía, it's the world the other way around from what it used to be. People now are all trying to value the properties high on inheritance tax to reduce the capital gains tax. Unlike in the past when they go low to reduce the thing. In other words, anyone putting a value on a property in Andalucía at less than what they're actually really inheriting for, it could be a mistake in the future.
Michael, absolutely. And let me just point out to people that is so important, the stage of doing things properly, fully informed with an expert, because doing all these things, I even had cases, Michael, where they did it wrong. And once you sign in front of a public notary and you say that, tax office, even though you just say, well, I'm sorry, it was a mistake, they will not accept it, Michael. They will not accept you changing your mind, saying it was a mistake that I put down 200,000 euros, but actually it was worth more, etc., etc. You've got a big fight, Michael, against the tax office to convince, because they understand it should prevail your declaration to start with. Even though it sounds very unfair, but I've seen different cases, Michael, where this did happen. So it's very, very important, completion date, to have already tax planning and know all the figures before you even sign, and to know all these tax implications. Very, very important, because as Michael stated, it will cost you money. Any slippery move costs you money. So it's good advice, Michael.
Excellent. Okay, I'm just reading, Ignacio, someone's written this problem that we're seeing with the capital gains tax. Someone's written in, because there are a lot of people that are very upset about these things.
Yeah.
It's a bit confusing, the wording, but basically it's someone that sold a piece of land in Cabo Pino that they inherited recently, and their solicitor had valued the property very, very low, 500 versus 100. And he's received a bill for 8,000. It wouldn't be 8,000, it's probably 80,000. He's missing a zero there, I think. 80,000. So 80,000 euro capital gains tax, because he's receiving a bill of 24% of the difference between 500 and 100,000 euro. That's where the problem is. So that's what we've already gone through that, and it is a mistake that is happening. And once what is it? Yeah, I mean, and we've already, we've had a client come in and say they wanted to know what they could do. If you're in this situation where you've got inherited a property, it's worth 500, and you valued it at 100, what we recommend, definitely, if you've signed acceptance of inheritance deed saying it was worth €100,000, but you haven't actually presented the tax declaration with the form 600, what I would do is go straight back to the notary, say that you've signed a deed of modification, saying that you've made a mistake regarding the values, and put a new valuation in. Definitely, as Ignacio said before, back it up with a valuation get an official valuation to explain why you're making that modification. And with that, then present your tax declaration, inheritance declaration, with the correct amount of 500,000, and you'll probably be okay. Now, if you've already made inheritance tax declaration, which is likely because normally you sign the acceptance of inheritance deed and you make the tax declaration straight after, and you've already declared on the inheritance tax deed the value of €100,000 that you stated on your deed, then I think it's going to be very difficult to resolve the problem, even though, depending on the amounts involved, you may give it a try. Definitely, you'd have to make make another declaration to the tax office, explaining the problem, back it up with a title deed, back it up with a valuation. And if there's a lot of money involved, like in this case, it may be worth a try, but it will probably be difficult. The other option that somebody said is, can I sue my lawyer? Can I sue my lawyer? Well, it depends, of course, on how those valuations were worked out. But I think the chance would be quite low. Because at the end of the day, the valuations, the solicitor, they're provided to the solicitor by the client, and that's I think that would be a difficult case for you. But if there may be room for, if the amounts are very high, to go back, and definitely if the inheritance tax form's not been done, then I would definitely go and sign a modification, and you probably get away with it. If you have done the tax declarations, I think you have to present another 600 form, a modification. You'll definitely, if it's done that way, you'll definitely receive a few letters from the taxman questioning what you're up to. But of course, if we're talking about €80,000 in savings in the next 2 or 3 years, it's definitely worth it. The conclusion of all this is what we've said before. If you've inherited in Andalucía, make sure you do not undervalue on the title deed. And we say this because we know it's happening, and it can cause a lot of unnecessary expense.
Very good, Michael. Actually, as you said, once you have this problem, it's very hard for all of us to put it right. But there are only 2 ways, as you said: rectifying the title deed and convincing the taxman that that's the right value and it was a mistake. But I'm unsure that will be a hard path for all of us. And the recommendation for today is do tax planning with proper experts, because that is the only way to avoid all these problems, Michael.
Yeah, absolutely. Yeah, and there's a last question here by Peter Pascoe to all panelists. Basically, yes, asking if there are a lot of differences between regions. Well, we've already said it, they're completely different. In other words, it's got the general system, and what each region provides are extra exemptions. So what you've got to do is make sure that the lawyer that handles your estate is aware of all the exemptions that are available to you in your particular region. That's the basics of that. Well, I think, Ignacio, we've gone through the basics. So
okay,
we can't. Unfortunately, we haven't sort of given the straight answer. How much is my inheritance tax in Spain, as we promised? Because it's not really possible. And it's just so that people know that it's not possible to simplify. And actually, I've just remembered something that I was going to mention before, Ignacio, and that is that what we come across very often when we go to probate are people that have received advice regarding estate planning that has led them down a path that is too complex for their own good. We see this quite a lot now People, you know, they're sometimes, in reality, inheritance tax in Andalucía is much less than what most people think it's going to be. And yet they have financial advisors advising them to do this complex products, you know, Spanish compliance bond, you know, in an insurance wrapper in Ireland, and all these things that may be the right thing, but they're the right thing for very, very few clients. In general, people can get away with a much simpler, simple will, simple procedure. Probate is much simpler if the will is simple. So you only complicate things with the will as far as estate planning if it's strictly necessary. So for someone, if someone says that you need to go beyond what you actually want to do, say for example, leave everything to your spouse and second step down to your kids, if anyone tries to complicate things beyond that, they need to be able to explain exactly why you're doing it, how much you're going to save, and more importantly, have they gone to probate on that will or that kind of product in the future? Because if they haven't, in most cases, what you're doing is you're just simply making something more complex than it needs to be in any case, and causing problems for the future. And in some cases, unfortunately, tying yourself in forever to that company because they're the only ones that know how to unravel what they've created for you. So that would be my last word of advice.
That's very good, Michael. And I will just like to send a reminder how important it is to make a will and power of attorney, Michael, because power of attorney, even for the probate, it saves a lot of hassle for all the beneficiaries. But even when people do a will, is always recommended to do power of attorney, especially elderly people, if they're going to sell, if they're going to do things in the bank, especially on those days, Michael. And tax planning, because once you do the will, once you do the tax planning, and once you do the power of attorney, you really have a full control of a situation of a specific year with a specific law, applicable law. And I think that will save a lot of hassle, Michael, and it's good advice. And unfortunately, not a lot of people do this way, but we highly recommend to do.
Yeah, no, we do as well. As people get older, Ignacio, we for younger couples, the wills, we sort of think that that's okay, that's sufficient. But as people get older, with the worry of future, maybe Alzheimer and things like this, what we like to do is, together with the wills, we think a reciprocal power of attorney between the two spouses to do everything is a good idea. We do that because if, for example, one of them becomes disabled, has Alzheimer in the future, or this sort of thing, and they need to sell, for example, the property so that the spouse that's okay can move back to the UK or to finance the home or whatever. If one of the spouses has lost consent and there's no power of attorney already in place, they'll be in a situation of having to go to the courts in Spain so that the judge can say if they can sell the property or not. And that in Spain, at least here in Andalucía, can easily take a year or two and is very expensive, the incapacitation procedure. So the reciprocal will is between the spouses to handle all financial affairs related to Spain is a good idea as you get older. In other words, if you get to the position where, you know, all these things start becoming a sort of a real possibility, you know, illnesses or having to move back to the UK, all these different things, the mutual power of attorney is also, so it would cover selling a property, you know, banking, at least those are the two basic things it would need to cover. Okay, Ignacio, thank you very much. I see Pedro, I think he's scared of all those questions that he's been seeing coming through on the...
I think he's hiding in the Javier office now, and didn't even make it to join in.
He's hiding away somewhere. The questions are too difficult. Okay.
Okay, Michael. Thank you very much.
Ignacio, do you just want to just give the details of your firm so that if someone in the Valencia region wants to contact you?
That's perfect. I will just leave it just in here. Is www.pellicer.heredia.com. It will be easier, alicantelawyers.es for easier spelling. Okay. And Michael, thank you for inviting me in your webinar, and looking forward to seeing you soon.
Thank you. Well, for those of you that know me, no problem. For those of you that don't, we'd like to meet you. And my name is Michael Davies. My firm is called Davies Abogados, Solicitors and Barristers. We specialise in inheritance and estate planning, and we have offices in Almeria City, Marbella in the centre, and in Majaca. And that's it. And thank you for watching. Oh, and if you're watching on YouTube, please subscribe to our channel. We're just learning the ropes of the ropes of YouTube. Of YouTube. Thank you.
Okay, thank you. Bye-bye.
Bye. Bye.
Bye.